It's so good to be here this evening. I think this is a wonderful opportunity just to share some ideas. I appreciate very much Farmers Bank, Tidewater Home Funding, and of course Gethsemane for hosting this event. And as mentioned, I'm an elder law attorney. I'm in North Suffolk. I've been in this area for about 17 years now. And I really, really love Farmers Bank too. It's because it's close to my office, and Tidewater Home Funding has just been a wonderful resource for many of my older clients. But a couple of things I want to talk about along the lines of protecting our nest egg. And we also called it kind of maybe 5 things you might want to do before you turn 65. Just a little bit of planning. We're going to talk a little bit about estate planning and related issues. And it's because there's just not a lot of things out there in life that are really, really certain, right? Just not a lot, but there's a couple that I can come, they're very pertinent this evening. We will probably all get old, at least we hope to get old. And we will also probably die at some point. But just for context, if the rapture occurs, that will not be true. But other than that, that's probably going to happen to all of us. And for that reason, it would warrant a little bit of planning for these things that are just kind of likely, almost certainly to happen. But some things about this, our life that we just can't really change. It's somewhat unfortunate, perhaps, but when we get older, we will almost certainly lose some of our physical abilities and our mental abilities as well. And I kind of think of this when I was a little bit younger, before I was a lawyer. I was often wondering, why is that individual in the left lane going 43 miles an hour and 55? Well, now I know it's probably one of my clients on Bridge Road or on 664. And I smile and wave at them now because I love them all. But it's really true. As we get older, we lose a lot of our abilities and really a lot of our not just physical, but mental as well. We notice I'm only 56, but I can't do the same things I could do when I was in my 20s. And another reason why we want to kind of get ahead of these things, they're just not going to change. Actually, they'll change. We'll get a little worse physically and probably mentally as well. But we want to plan ahead because once we're kind of late in the game, you don't know it. Just today, I was visiting in a nursing home in Smithfield with a little lady. She was somewhere in her mid to late 80s, real nice. Started a little bit about myself, and she asked me, I quit counting it 5 times. She kept asking me, what does my wife do for a living? Right? I told her, I was very polite. She didn't remember. She had short-term memory loss. And as I was leaving, she asked me my name again for probably the 4th or 5th time. But we want to put these plans in place before it's kind of, not want to say too late, but once it's a little late, we might not even have the ability to do it. And another reason as well, and it's because we don't want to burden our family with these decisions. Some of these things seem so simple, but for example, medical decision making. Who do we want to have to make medical decisions for us once we get a little older? Perhaps our mind may not be quite as sharp, but if we don't make these decisions ahead of time, our family will have to make decisions. Sometimes that's incredibly constraining on them. It's very stressful, kind of wondering what would mom or dad want to do. So we make these decisions ahead of time. And then I'm going to go through a few things. I kind of gave like 5 little bullet points here about some of these things we're going to want to do involving protecting our nest egg, as well as just things we need to do before we get well past that point when we're older. Maybe we don't know what's going on around us. But the first is creating a will or estate planning trust. And some people say, well, do I need a will? You know, I don't really have much of anything. But one, everybody has a little bit of something. But we want to determine who gets what we have. Now, is it really necessary to have a will in Virginia? No, it's not necessary. And if you don't have a will, the government's not necessarily going to get what you have. Some older clients say, I gotta have a will, I don't want the government to get what I have. Well, the government's not going to get what you have. Actually, occasionally it does happen. But if we don't have a will or estate planning trust in place, the government will kind of decide for us. Now, if you're a really, really boring person like I am, I've been married to my wife, Hope, for going on 31 years. I have two children that are 19 and 20. We have a kind of a traditional situation. In my situation, if I didn't have a will or trust, my wife is my heir at law. If my wife predeceases me, then my children are. So that would work for me, but I don't want to rely on the government's plan for my estate. Will it work? It might work for some people, but it's not something we generally would want to rely on. And then when we do create that will or estate planning trust, along with our power of attorney medical directive, we want to tell the appropriate people where we keep these documents. And let me give you a real good example. I know some of you out there heard my radio ads. They run all over the area down here, all the way from the Outer Banks up to Williamsburg and Franklin. And I know some of y'all heard about Skippy the cat, a commercial I made about a kitty cat. Well, this fellow that I met actually from a presentation I did at a church in North Suffolk, he came and met with me, and he was a little bit strange. He real nice guy, but you could tell he wasn't a people person. He's not one of those people that probably enjoyed being around other people, but he was very much a cat person. And he was very, very evasive with me about what he had in terms of his estate. But he was very certain about, he wanted that cat taken care of. And it seems kind of odd, like a cat, you really want to take care of a cat? Well, it was his lucky day. I'm a cat person. I like cats and dogs, but if I could have one or the other, I like them cats. I have more meaningful conversations with my cat than I do sometimes with my children, because sometimes my children, they don't even acknowledge my presence. The cat usually acknowledges my presence. But this fellow, I'll call him Paul, that was his first name. He really wanted to make sure that cat was taken care of. It seems ridiculous, but he also did not want his distant relatives to get his money. Well, we had a trust for Paul, and the cat was fine. He did bite me. Well, he didn't bite me. He bit my wife quite a few times. He never bit me. But we want our assets to go to whomever we want to go. And some of the people too said, older folks that maybe don't have children, and they say, I don't really know what I want to do. Come meet with me. I'll give you some ideas. I tell you what I've done in my own estate plan. I've got a wife and two kids, but I don't have a lot of really good takers outside my immediate family. I tell you what my estate plan does. It leaves my estate to my church in the event that I call it my rapture provision, that my wife and kids are gone, and we don't have any offspring. I make provisions for my church. In fact, my cat guy, Paul, he had about a $2.7 million estate, about 2.4 million. We left 300,000 to take care of Skippy the cat. 2.4 million went to mostly local charity nonprofits, two of which were churches, and a third was the Billy Graham Evangelistic Association. And I tell you, that felt great, writing checks for $750,000 each for the Lord's work. But anyway, that's what we can do in our estate plan. Not leave it to relatives maybe we never met, or we met them and maybe we wish we hadn't met them, but we can leave our assets to whomever we want to go to. And then we also want to regularly review our estate plan, as well as the impact of certain events that happen in our lives. Some of you, I know you'll feel like I'm preaching to you right now. You may have a daughter that's wonderful, but she marries this dude that you wish she had never met, right? We want to make sure that joker never gets any of your money. And we can do that with an estate plan as well. If we have beneficiaries that are family members, beneficiaries that are financially inept, maybe have drug, alcohol problems. I have one of my near relatives said, well, I guess whatever I'm going to leave my daughter is going to go to all of her creditors. Oh, no. We have a spendthrift trust provision. So we have a child that's a spendthrift or up to their eyeballs in debt, that money can go to that child and not to their creditors. There's a very legal way to do it. In fact, the one individual said, that sounds illegal. I said, no, it's quite legal. It's quite legal. But these are the things we can do with our estate planning trust. Again, we want to regularly look at it. We have deaths in the family, marriages, divorces. These are things that want to cause us to just look and make sure that whatever we created, whenever we did, is still appropriate. And for many people, a will may be the best option. And some folks say, "Well, I don't have a lot of money. I don't need a trust. I think a will would suit me just fine." And for some folks, that's just fine. If we have a will, I'll caveat this later, but that will likely mean a probate estate. Is a probate estate bad in Virginia? It's not horrible. As mentioned in the introduction, I'm one of the commissioners in the Fifth Circuit, Commissioners of Accounts in Virginia. You can, in most jurisdictions, not all, you can still be a private practice attorney. And then our commissioner work, we keep that segregated from our regular law practice. But I'm one of the commissioners. I don't mind probate estates. It's more work for me to do. But as I tell my clients, that's probably not the best way to do it for most people. If we have a trust, we can avoid probate. And the bigger thing is providing for underage beneficiaries and beneficiaries we might have with disabilities or some limitations. So again, think of the child that maybe has not married well, or they've had financial limitations, and you may leave $100,000 to that child and thinking, the creditors are going to have a real feast right there, and your daughter may have a famine. Well, we can leave that in a particular type of trust where that child can benefit from the money without the creditors getting that. And this is probably a good time to mention as well, we have a will or trust, should be right there in the middle of the slide there. We want to be very sensitive to the asset titling. And I'll give you a case that I worked on. This was right at 20 years ago. I've been a lawyer for about 22 years now. A case I was working on not long out of law school. An individual did not have a will. They said, "Well, I don't really need a will. I only have I think they had about $225,000 in a bank account entitled that jointly with another person." Thinking, I don't really need a will. I can just title that money jointly. Will that work? It'll work, but it's subject to being challenged. So if we have money jointly titled with an individual, let's say maybe we have a will that says I leave everything equally to my two daughters, and we have one account jointly titled. Let's say we got a farmer's bank account with make up a wild number, $82,000 in a farmer's bank account. It's titled jointly with daughter one. We have a will that says everything equally to my two daughters, right? The decedent, the parent dies. That one daughter that's joined on the 82,000, she gets that money right off the top, in addition to half of the other assets. And I hear this all the time. "Oh, my daughters, they get along fine. They're going to share everything," right? I know some of you are smiling like, "No, that ain't going to happen," right? They're going to be fine till the day you die. Then they're going to pull them claws and knives and guns out and going to start shooting at each other. So we don't want to create a situation where asset titling would supersede the provisions of the will. And I can have a will or trust as everything equal to these two people, but if we have a child join on a bank account subject to a number of considerations, that individual join on the account will receive that money. And along the line of trust, people can say, "I don't have a lot of money. I'm not rich. I don't need a trust." Trusts aren't just for rich people. They're great tools to, one, avoid probate, as well as throttle distributions to beneficiaries. I enjoy my work as a commissioner, but one of the things I hate about the job is when we have an individual die. They either die with a will or with no will, and they leave behind minors. All right, and you say, "Well, what happens there?" Let's say we take an individual that dies without a will. I had one case in Suffolk. I'm the commissioner on. There were two minors. I think they were like 10 years old child. The other was 14 or 15. And actually, this one had a will. And he says, "I leave my house to my two children." Well, these minors can't accept title to real estate. They don't have the capacity. So it was a sad, very sad case. A lawyer was appointed the executor of the estate, his individual name, like, "I'm not going to touch this one with a 10-foot pole. It's too much trouble." I don't know how many hearings that the executor has faced, had to follow a whole bunch of documents with me just to get authority to sell that real estate. I'm talking $10,000, $12,000 in legal fees just to sell that real estate. If they would have had that property in the trust, that property could have been sold, no court supervision, would have been a great thing. So don't think, well, I'm not rich, I don't need a trust. A will may just be fine for you, as I noted there at the top, but it's not, don't think just because you don't have a large estate that a trust is just something that you don't need because you have a small estate. Let me mention estate taxes as well. This comes as a surprise to quite a few folks, but the estate tax threshold is up there in the stratosphere, right? What is that? Well, it's a little over $12 million right now. So if your estate is under $12 million, you got something else to be happy about because you don't have a taxable estate. So we don't really need for most people to do estate planning trust for the purpose of avoiding or minimizing estate taxes, right? Just not much of a consideration. We do have a few people in this area. There are not many of them that have estates in the 10, 20, 30, 50, $100 million range. I've only had a few in my whole career that were more than 10 or $12 million. I'm a CPA, I file plenty of tax returns, but it's pretty rare today that I file an estate tax return. But today, we don't even need a trust to avoid estate taxes. We have other ways of doing that. So again, just want to clarify that the trusts aren't just used for estate taxes. We use them for a host of other reasons that most normal people, especially again, if we have minor beneficiaries, grandchildren, or we have children that have any type of limitation, either financial limitations, drugs, alcohol, mental illness, we can provide for them without letting them have complete access to that money. As well as if we have someone who's on Medicaid, we really need a trust at that point so that individual can benefit from the money without losing their Medicaid benefits. The second kind of little tool in the toolbox we use to manage our affairs as well as protect our nest egg is a power of attorney.
Hey, Tim, before you move into the power of attorney, we have a couple questions in the chat, if you don't mind me. Thank you. The first question we have, is there a certain amount of assets that one should have before considering a trust?
Good question. Here is my threshold for when it's cost effective without any other considerations. For example, let's say your children are squared away, nobody's on drugs, we don't have any minor beneficiaries, and it's just a plain ordinary boring estate like my own, right? The cutoff for me is about $500,000 estate. That's when the simple economics of a probate estate, this is just the cost of it, makes it a no-brainer. So $500,000 generally, including your real estate, your probate tax, inventory filing fees, accounting fees. That's the kind of the sweet spot for me. If we had less than that, but we have minor beneficiaries or we have a delayed distribution, obviously less than that would be something we might want to consider using a trust.
Thank you. And then one other question is, what is probate?
Good question. What is probate? Probate is simply the system by which assets go from the dead people to the living people. It's a system in Virginia through the Virginia Circuit Court system where an individual dies. And let's think of the best example. Somebody dies and we're trying to get to their house or trying to get to their bank accounts, and we can't do it because the nice lady at the bank says you need some papers from the court. Those papers from the court would be involved in the probate system. So the probate system involves presenting a will to the circuit court, an executor or an administrator qualifying under court supervision. And then that individual must show the court they paid the bills, they gave the beneficiaries the money, there are no outstanding taxes. And then once all that's done, the executor or the administrator can close out the estate.
Thank you, Tim.
All right, any other questions on the will, trust? Well, if not, we'll move on to the power of attorney. And this is the most fun part for me, the power of attorney. It sounds so, so simple. And many people, they have a will and they did it 30 years ago and they don't have a power of attorney. And you'll see the first bullet point on there. I often view that power of attorney more important than a will. It's like, how could a power of attorney be more important than a will? I'm not saying it's not always, but I tell you, that little lady today I went to see in Smithfield at the Riverside facility. Some of y'all probably know where that is. Actually, it's not even hardly a stone's throw from the Farmers Bank branch there in Smithfield. But this little lady, mine's kind of shot. This is the one I was telling. She asked me several times what my wife did for a living. As I was leaving, she asked, asking me more and more questions. But her two children did not have any means of accessing her money. They just didn't have the ability to. So it's like, do you have a power of attorney? If we have a power of attorney, our parents, grandparents get older, then we can access their money. So that's something for my older clients. I'm more interested in talking about that than I am their will, because it's absolutely critical when managing the finances of an incapacitated person. And remember on that first slide there, so it's kind of two things, they're probably going to happen, right? And you kind of hope the first one happens, you get old. If not, you don't get old, that means you're going to die prematurely. And that second one, you're going to die. But you notice they're in that order. You're going to get old, right? Probably. And then you will probably die. That will is not going to do you a lick of good till you're dead and gone. That power of attorney is an instrument that could get a great deal of utility for a long, long period of time. And I'm going to tell you too, the reason why I'm so emphasize having a power of attorney is the alternative really, really stinks. One of my many jobs as the commissioner is overseeing guardianships and conservatorships in Virginia. And that's when we have an incapacitated person. There's no ability to manage their affairs. And we have to go through this very arduous process of having a guardianship and conservatorship, right? So if you really want to get your kids mad at you, don't have a power of attorney, right? And lose your mind later on, and they'll really talk bad about you when you get old and they have to go to court, because it's an extremely involved and costly process for that guardianship, conservatorship. And the power of attorney doesn't always obviate the need for that. I have some older clients with a power of attorney that maybe have severe cognitive issues, sometimes associated with dementia. Sometimes they're just a little senile and they think the kids are trying to kill them, trying to steal their money. Sometimes then we still have to go to court for a guardianship, but I would say probably 9 out of 10 times, maybe even 95 out of 100, if we have a power of attorney and then the elderly individual becomes incapacitated, we're able to get by with that power of attorney without having to go to court for that guardianship. So just a little bit more on the power of attorney. We can name multiple agents as the under the power of attorney. We don't have to do a one, then two, then three child. But let me just tell you a little bit about naming multiple agents. All right, I'm fine with two. If you have two kids and they get along, you can say, Joe and Sally, either of whom may act independent of the other, right? That'll work. Sometimes a bank will have a little problem with that. They want both people to come down there and sign the documents. But three or more just doesn't work. I can't get three people in my office what to decide for lunch, right? You can't get three people to decide what course of action to take for an elderly person. I prefer one person as the agent. You got one coach, you got one quarterback. I could go through the laundry list of having one person in charge. And that's my preference. If somebody has two kids and they get along, I say, yeah, we can do that, but I still prefer to have one. The power of attorney can be effective immediately or take effect at a later date. It's called a springing power of attorney. Your power of attorney may say, only when I'm incapacitated will it be effective. I do not recommend that. Try to get a doctor to say a patient is incapacitated for the purpose of springing a power of attorney. That he's not going to do that, or she's not going to do that anytime soon. They don't want to get involved in a family dispute. People often think too, the power of attorney can do whatever they want to do. I will give you plenty of good examples how that is just not the case. We have a circuit court system in Virginia, and we have a very, very solid judicial system that's intended to protect incapacitated elderly people from agents that might abuse a power of attorney or take inappropriate action, and they can actually absolutely be held accountable by interested parties. So I've had many kids say, kid, they're my age, you're on the power of attorney, I can do whatever I want to do. No, you can't do whatever you want to do. You're held to a fairly high standard. And a most beautiful thing we had in the last 10, 15 years, the Virginia adopted legislature, the Uniform Power of Attorney Act. And years ago, we might go to the bank and the individual of the bank may say, I don't really like this. We're not going to accept it. Now, if that power of attorney complies with the Virginia Act, there's a penalty provision for failure to follow the directions of the agent. So it works well. I've not had a single bank yet get in any type of difficulties with this act. But do remind sometimes if individual will not accept the power of attorney, there is a penalty provision for failure to do so. But again, that power of attorney, a wonderful, wonderful tool. And again, that is for the management of financial affairs. The next instrument we'll talk about, a medical directive, that is for medical.
We actually have a few questions in the chat.
Absolutely.
And I'm going to call on a few people. Samuel, I believe, has 2 questions. So I'm going to ask him to unmute.
Okay, thank you. Thank you. I appreciate that. Thank you, Attorney Palmer. My first question I was asking a little bit earlier, and I didn't get to get it to you before you moved on to the power of attorney, but the asset titling, I wasn't clear exactly what that meant. And also, what are the advantages and disadvantages of the asset titling? And then the second question was just in terms of what you're talking about now, the power of attorney. I understand you're saying you can have an agent 1 and an agent 2. I was asking as far as a joint power of attorney, if in a family, for example, you wanted your sisters or brothers to be the power of attorney jointly, what is that possible? And if so, what comes into play if you got an even number and both of them and they're split on what they decide, how that is handled? And could the joint be a person and an agent like a church or an organization? So if I wanted to have siblings and the organization to jointly be a power of attorney.
Sure. Let me address the first part of that, the asset titling. It's very common with older folks to put a child on a bank account, right? So that seems very innocuous. When the assets are joint with an individual at death, generally that joint owner gets that asset without any offset under the will or the trust. All right. So let's say I have $200,000 and I have $100,000 joint with my son. I die, my son gets that 100,000. My will says everything goes 50-50 to my 2 sons. My other son's not going to get 100. He's going to get 50. And my one son that was joint on the account is going to get $150,000. Okay. Now, if your kids get along and they're willing to share, that might work. But so many times they can't or they will not share that money. So when we're preparing a will or estate planning trust, I always want to see a list of assets and how they're titled. Because if we prepare a will that says, again, equally to my 2 children, but assets are titled otherwise, then those assets will not go equally to the children. Likewise, we have some older clients, I'm worried about going to nursing home. I'm going to put my daughter on the deed. What the translation means, I want to give my house to my daughter. Is that a good idea? Well, it may be, but one of the things I want to do is see what are your estate planning goals? Do you want to leave everything to your daughter? If you have a house worth $250,000, you give it to your daughter, what's left with those other kids? So the whole idea of asset titling, we create a will or trust, and then we must look at how the assets are titled to ensure that plan that we created will actually work. Now, let me jump over to the joint agents. The question was, can we have 2 agents, maybe a child and an institution? It could be a church or some other organization. Can you do that? The answer, of course, is yes. But as a law professor told me the first year of law school, told the class, there's a lot of things you can do that are really bad ideas, right? And that's one of them. I do not recommend having an individual joint with an entity, and it's for the most, to me, it's kind of an easy way of expressing it, is that organization to take certain actions generally requires a body of people to make a decision. Let me just give an example. Catholic Charities. All right. I work with them regularly in Jewish Family Services. They often manage the affairs of an incapacitated person. And I've seen this happen more than once, Catholic Charities joint with, say, a brother or sister. Imagine the division that can come over very, very, very simple things. And then you get into a standoff, and then we're in the circuit court. And the whole idea of doing this was to avoid a court proceeding. So I always say, pick the person, one single person or entity that you trust, and then we have a backup in the event that one cannot act. The exception being, you got two kids, they're squared away, they're swimming in the same direction, similar value system. I'll say, okay, that would be fine, especially if they live in the same area. But I generally do not recommend two individuals joint, or certainly not an individual joint with an entity, because of just the built-in likelihood of a problem. And I say, well, if you don't trust one, go with the other. If you trust both of them equally, flip a coin, but don't have the two of them tied together.
Thank you, Tim. And we have another person raise their hand in chat. Jamie, I'm going to ask you to unmute.
Yes, I actually put my question in chat, but it is, I'm already in a situation where I'm a guardian / conservator. Can you dissolve that in favor of a power of attorney, or is that advisable? Because I actually don't like the conservatorship the way that it's going. I just thought it was the thing I needed to do.
You're in great company in that you don't enjoy it. I've never met anybody that enjoys a guardianship conservatorship. I also have never met anybody that enjoys getting stung by hornets either, because I mean, they're both just, it's unpleasantness. And I'm just going to give you a little side story. My bias toward that is, once you do that, it sounds so cool, but once you do it, you tie yourself into enormous commitments and expenses. And so it's always a last resort. But can you bail out? The answer is yes. The Virginia Code actually encourages the fiduciary, the guardian conservator, to restore that ward to capacity, right? So if we have an incapacitated person, that's considered not a good thing. We don't want to declare people incapacitated and take away their ability to control their fate. We don't want to do that. That's a bad thing. So we can unwind those. It's a little complicated. We have to file a petition in the circuit court to dissolve it. I have seen it done more times than I could tell you. I say at least a dozen times in the last 20 years. But I tell you, if it becomes too unpleasant and it doesn't look like the restoration is feasible, the two organizations around here I'm very familiar with, I get accountings from them at least once a week. Catholic Charities, Jewish Family Services will often take over that role. And they do, in my observation, a very good job. But can it be unwound? Absolutely. But we have to demonstrate to the circuit court judge that this is no longer necessary, and this person is no longer a harm to themselves. For example, we may have a conservatorship because we have somebody, I've seen this many times, mentally ill, inherit $500,000. Mentally ill, they're going to blow that money up real quick. They're delusional. Had one guy branded some money. It was a son of a client of mine. He down 664 in a cab, throwing $100 bills out the window because he thought he called it NASA. I think he meant the NSA was tracking him. And if you got a good look at this guy, you'd be certain nobody wanted to track this guy anywhere. But he really was throwing money out the window because he thought people. So we wouldn't have got a conservatorship, a guy like that. Judge's not going to want to unwind it because that guy would lose that $500,000 real quick. But there is a procedure to do it. And if it can't be unwound, there's two charities in this area that are very capable of doing that for you.
Okay, thank you. We have a few more questions in chat. One is from Maxine. They ask, at what point does the power of attorney expire?
Good question. The power of attorney in Virginia, as long as there's no timeline, it only expires at death. And there's even one act the agent can make after death, that generally a power of attorney expires at death unless it's revoked. So The principal, that's the person that signed the power of attorney that created it. They can revoke it, typically in writing. They could verbally revoke it. At death, it terminates, but generally there's no 1 year, 5 year, 10-year limit. It goes to death or until it's revoked.
Perfect. And I'm going to butcher this name. Akia asks, what's the best or the recommended age to have power of attorney docs created?
Good question. Certainly, as we tell you, before age 65. Well, that's kind of silly. I would tell you, I mean, it's just kind of, I feel kind of uncomfortable answering the question. I'm 56 years old. I was in my 30s when I did it, just because I was having children at that time, and I was more worried about my children being taken care of. But I'd say a good time to put all this together. If you're married, especially if you have children, you need a power of attorney in place. And it seems silly, 30-year-old guy, why do you need that? You're busted up in a car wreck. Your wife's trying to access your money. Believe me, she doesn't have that. She's going to have to go to court for a guardianship, conservatorship. If you're a young single person and you don't really concern yourself with such things, yeah, let your parents clean that one up. But if you're married, especially, and have children, no magic age there. But how many? Just coming this way, I was coming back from Virginia Beach at about 5 o'clock, hung up in traffic on 264 in Norfolk. There was at least 8 cars busted up in a crash over there. I don't think anybody hurt or killed, but I was thinking, man, those people all have a bad time ahead of them. And if any of them were in the hospital unconscious, there's somebody's not even be able to pay their bills, pay their rent, pay their mortgage for them.
Perfect. And Annie asks, we've spoken specifically on Virginia, but do these procedures work similarly in North Carolina?
If the question is about guardianships, conservatorship, the answer is yes. There's a different court, like Virginia, we have the circuit court system for guardianships, conservatorships. North Carolina has a very, very similar system. If the question is more broad about a power of attorney, North Carolina and Virginia have very, very similar legal systems, very similar common law systems. In terms of what do we need to do for a power of attorney, and the same for a guardianship. But in every state in this country that I'm aware of, that guardianship proceeding is a formal court proceeding that's overseen either by a judge. In some states, like in Alabama, they have what's called a probate judge, not even a lawyer, that oversees that. But power of attorney and guardianships generally, anywhere you go in this country, we will have a similar system and set of rules in place.
Okay, great. And we have one more question in the chat. Ms. Wanda asks, will you explain how effective or ineffective a trust is when you have a blended family?
I tell you what, I'm going to take away the preacher time, right? I can give you a 2-hour sermon on that. Though blended families, my goodness, you have got to have an estate planning trust in place. I could bore you and make some of you cry with horror stories. And it's all about men, by the way. Men are just the dumbest gender on the planet. They don't, a fellow loses his wife, death or divorce, and at the funeral, he's out there looking for a replacement. By golly, he finds one, he dies, and everybody hates each other for the next 15 years. But that trust is a great tool for blended families, because the conflict is between the spouse and the children that are not of that spouse. And I've got a bucket of tools just for that, often involving life insurance. And sometimes we use 2 separate trusts one to take care of the spouse and one to take care of the children. But that is a must, absolute must for blended families. When an individual, man or woman, remarries and has children from a prior, whatever cost you're going to incur, you need to add a little bit to it to take care of the legal fallout. I won't be too negative, but I've so many people that want to remarry. Like, you need to think this through real carefully, because the legal implications and the consequences of that are extraordinary. And everybody's in love and wants to get married, and I'm the naysayer over there. Hey, you need to think this through, because the day that you marry someone, they have what's called incohate rights in your property. You can be married for 1 day in Virginia. Incohate simply means, we can't really define or describe it, but it's just as real as the sunrise. And, but certainly blended families, that there's not a blended family client I have that I don't have in a trust. And it's a very, very good tool to accomplish that goal of taking care of the spouse and the children without cutting out either one.
And we have another question in the chat that came in while you were speaking. Approximately how much do these processes cost for power of attorney and estate planning trust?
Sure, that's a very, very reasonable, fair question. I won't give you a lawyer answer to that either. I'll give you a range of what typical lawyers would charge for an estate planning, a plan that I typically do. A very, very simple, where we didn't have a trust. And with that, we'd have a will, power of attorney, medical, directive. On the super, super, super low end, that would be probably in the $1,500 range. We have some clients, blended families, that have issues such as children that may be spendthrifts, alcohol or drugs. That could be well in excess of several $1,000s. I've never had one more than I think most ever was $15,000. That was somebody with about a $6 million estate. I think 2 ex-wives and I don't know how many children from different folks. And we had a layer of complication, more typically somewhere in maybe the $2,500 range. There's some lawyers that'll charge 2 or 3 times that, and there's some that'll charge half of that. But just a general range. I know that's kind of a little bit, a little vague there for you, but that's a very fair question. I want to give you a fair answer on that.
Thank you. And one last question. Somebody asked, they have an autistic grandson and they were told that they need to look into a special needs trust. Are you going to speak on that tonight, or if not?
Yeah, no, I can. We'll have to compress the time. I'm going to look at Allie there. If she gives me a hand gesture or an ugly look, she'll cut me off. But I can talk longer than any of you people could stand to listen to me. Believe me, I can go to midnight. But they told me I only had 2 hours anyhow. No, we're not going 2 hours. But yeah, a special needs trust, when we have an autistic child or a child that maybe on Medicaid, is on Medicaid or SSI at some point, the gist of that supplemental or special needs trust, the acronym SNT, if you hear SNT, supplemental or special needs trust, is having money for that child without interfering with public assistance. All right. And that's exactly what we do for that child with autism or any other type of limitation that could lead to them being on any type of needs-based public assistance. And there's a difference between, say, SSI and SSDI. I have one client, I can't get her to understand, her son is 62, 63 years old. He'll draw Social Security when he retires. It's not needs-based. So we can, anybody who's working is going to get Social Security. You can get disability income from a work history, but someone who's disabled and impoverished, there's a separate program. And those are the ones we do not want to leave money directly to. We leave it to them in a supplemental or special needs trust. So one of the many, many useful reasons or reasons why we might want to have a trust instead of a will.
Thanks, Tim. I know we have a few more questions in the chat, but just to make sure we give you enough time to share your other keys to protect your nest egg, we'll continue to the next slide and hopefully have some additional time at the end to address those questions.
Well, I am here for everyone, so I'll just follow your lead there, because none of this is more important than the other. But let me try to go through real quickly the rest of these. So the Advanced Medical Directive is a mechanism where we can allow 2 things. One, a medical decision maker, as well as state in advance our end of life decisions. All right. And to use the, I think I've got it on the next slide just for the fun of it. I think I had Ricky Bobby on there. Yes, some of you might know who Ricky Bobby is from Talladega Nights. Y'all may remember when Ricky Bobby thought he was dying, was in the hospital, and his supermodel wife says, "Doctor, go ahead and pull the plug." Y'all remember that scene in the Talladega Night? It's just a stupid, funny movie. And the doctor said, "Oh, honey, he's not dying. He's just sleeping right now." Right? Well, that's kind of the idea. If he was like, "I have some little delays. I don't want to sign that. I don't want my daughter to pull the plug. She's been waiting me for to die the last 25 years so she can have my house." Well, if we have a medical director, they're not going to pull the plug. Not going to pull the plug on you. That's a decision that would be made only after the medical providers determine that no further medical care would really be helpful. And it really relieves the doctors of medical malpractice liability. But I have a medical directive. I don't think I have any irrational fears of dying. I don't want to die, do certain things to live, but I know where I'm going when I die. I don't worry about it all day long. And that's one reason why I have a medical directive. I told my wife, when I die, act sad for about 2 weeks. Don't go buy a new car right away, but I'm not worried about dying. And so I have that medical directive, and that just takes the burden off my family. If I'm busted up in a car wreck or have had a stroke, I want my family to do what they can to help me, but I don't want to be put on life support. That's what that medical directive does. But again, just because we have a medical directive, our supermodel wife's not going to be able to pull the plug on us and kill us off right away. But beware, if you're sleeping at night and your wife comes to bed with a pillow over your face, that's a sign maybe you got marital problems too. But we can, just like the power of attorney, we can choose more than one agent to act for us. Again, I kind of like the idea of having one agent, one person in charge. I'm going to kind of skip over the next one, inventorying your assets. That's kind of always a good idea, no matter what your estate plan is. Let somebody know, trusted. I say let two trusted people, where your little hiding place is, where what you have. And the reason why that's so important, we have older people that die. We lose assets. There's things out there nobody knows about. I can't tell how many times I've gone through houses and find gobs of money or savings bonds shoved somewhere. And then I think, how many of the ones I found, how many did I not find? What I keep, for me, my wife's stay-at-home wife's not interested in money or anything else. I just tell her, hey, something happens to me, a little notebook on my desk here with my passwords in there. And every time I try to share our finances with my wife, she says, you got cancer, something wrong with you. My wife doesn't want to know. I want my wife to know what I have in case something happens to me. So I'm just going to encourage all of you, if you have an estate plan, have some list of what you have. I update mine at least once a year, where my life insurance is, my retirement money. Ordinary things around the house are not that important unless you hide large sums of money or jewels. You don't really need to worry about this. Really your accounts and your passwords. Don't hide your stuff. Obviously, if you get old and lose your mind, that's what you'll be doing. So before you lose your mind, tell your kids where you hid all your stuff before you lose your mind. Let me jump in the last one. I'm trying to make this real quick, because I know this is probably the one thing that I should have done this first, because this is something most people are incredibly interested in, protecting your assets. All kind of risks out there. We have a lot of clients worried about going to a nursing home. Let me put my assets in my son's name or my daughter's name. It's okay to be a little concerned about it. There's a lot of risks out there. Don't let the nursing home paralyze you. There's all kind of other risks out there. I'm a big fan of liability insurance. You ought to have on your car at least $300,000 to $500,000 in liability. People worry about a nursing home soaking up all their money. You're more likely getting a car wreck, rearing somebody, and have too little insurance than you are to go to a nursing home and lose your money. Obviously, be very, very, very careful who you trust. Most of the exploitation cases I see, they are not from strangers. They're often from family members, a close friend or neighbor. And you see my little icon, a little picture in the bottom, protecting your assets. You don't need a cannon. That's kind of what I want in my front yard. My wife has vetoed that, so we're not going to put a cannon in the front yard to protect us. But there are many things we can do to protect what we have. Again, always insurance first, liability insurance on your car. And let me jump over. I mentioned two umbrella insurance. $1 million umbrella for most people is less than $500 a year. If you've got teenage drivers like me that have rear-ended somebody on Bridge Road by my office, it costs quite a bit more than that. But big fan of that umbrella insurance and your homeowners as well. And then let me jump over to long-term care real quickly. You'll see another character down there in the bottom. Some of you may remember that. That's Happy Gilmore. His grandma was in a facility, went broke, and he had to go on the PGA tour. He didn't go on the LIV tour. He went on the PGA tour to make money to pay for grandma, because y'all remember what happened to her house? It got taken for taxes or whatever, mortgage. She couldn't pay her mortgage. And I just noted their lifetime of savings, y'all, can be wiped out in less than 2 years. Long-term care insurance needs to be evaluated very carefully. Some of that stuff is incredibly expensive. I look at if it's costing more than about 10% of your gross income, you probably are paying too much for that. It is not a silver bullet. I tell everybody, self-insure, plan ahead, put money aside, consider self-insuring. Do not rely on Medicaid. Is Medicaid the answer? Probably found more Medicaid applications for long-term care than anybody in the Commonwealth of Virginia. It's something I know and familiar with very, very well. It's a federal program. It's means tested. That means you can't have a lot of money. Gifting rules limit artificial impoverishment. And my last one there, you really think the government has unlimited funds? So Joe's even saying right there, look, we only got so much money, right? The federal government only has so much money. I tell you, don't rely on the federal government for Medicaid, but it's a system out there. It works. It's changing. Like I said, I'd probably do more of this than anybody in Virginia, but it's an extremely strict program. As I mentioned there on the last page, I think we got a picture of a guy on that next page there. He is flat busted broke. He's sitting on a rundown recliner in front of an abandoned building. All right, being broke is not enough. I have plenty of people come to me, other nursing home, $30,000 and have no money, and they're not eligible for Medicaid. Why aren't they eligible for Medicaid? They're broke. They might have a life insurance policy that puts them over the limit. There's some stock somewhere they can't liquidate. But we do have provisions to protect community spouses for married couples. Never had a married couple go broke, as long as we get the help and the right advice. But I always want to get an expert before you run on Medicaid. It's a good system, but it's incredibly complicated. As I noted there, it's a last resort. We don't plan on Medicaid or the federal government paying for a nursing home. But I know how many people over the years, it's got to be pushing 1,000 now that we've got folks on Medicaid. But I tell you, don't plan on that. But if you're there, that's something that someone like me can help you with. And I know we're probably a little bit past the time there, but I don't know if we have any time for questions. I want to be respectful of everybody's time, but conclude, get your act together. Don't put this stuff off. And there are a few things in this world that are certain. Very few things are certain. They say taxes and death. You can beat them taxes. I got quite a few people aren't paying any taxes. You cannot beat that death. And if you're fortunate enough to get old, you're going to have something else to deal with. But I thank you all very much for the opportunity. I could talk again all night long. And I think maybe if there any other questions or thoughts, Sally?
So I'm gonna pass it back to TC. I know we have a couple questions in the chat, but TC, I'll let you kind of lead the charge.
All right, so Tim, thank you. This was awesome. I got a page full of notes. This is really good, and I think everyone shares that sentiment. As a matter of fact, if Tim did a good job, do a reaction now. Hit your button, throw the hand clap, or cut your camera on, and pump your fist. Something. All right, Tim, they feeling it. That's awesome. So look, I would like to make a last call for questions. You can drop them in the chat or raise your hands. And if there are no other questions, then we will kind of move towards closing us out tonight. So last call for questions. All right. Well, Tim, I don't see any other questions. So Tim, I'd like to offer you any closing remarks, sir. Again, thank you for sharing with us. This was really good.
Well, I appreciate the opportunity, and I want us all to remember this is kind of important stuff. There are bigger things in this world to worry about. Your salvation, your future is far more important than any of this. But while we're here, we're going to deal with these things. And again, thank you so much all for having me here, and very much appreciate the opportunity.